Hi, I'm back. If you have listened to me talking about the application of logic to law, if you have not, I'm here for the first time. So my name is Pedro Moniz Lopes. I'm a professor of legal philosophy at the University of Lisbon. And this time around, I'll be talking to you about analogy. So analogy is very contested concept and discussed within legal theory. There are many theories about it. There are also many presuppositions that need to be expounded upon to better talk about analogy. But my purpose here is it's very moderate since I have 10 minutes to talk to you about analogy. I will basically do the outline of the uses that one can make of analogy in general reasoning and particularly in legal reasoning, because you have analogy in general, you have analogy in fact finding, you have legal analogy, you have historical analogy, political analogy, scientific analogy, and whatnot. Um, but in legal reasoning, we have legal analogy. So I'll just briefly outline the uses that one can make, sort of uh, clarify the conceptual apparatus um, that we can make sense of when talking about analogy, and specifically structure. I wish to structure the inferential steps of analogy. Of course, this is a specific theory of analogy, the inferential theory of analogy. There's many interesting papers written on this, particularly one by Damiano Canali and Giovanni Tuzet, called Analogy and Inferential Approach, something like that. So you can easily find it on the internet. It was published in Ratio Juris, I think, in 2011. So starting off with the uses of analogy. What are the uses of analogy? So analogy in general is not only used for problem solving. Analogies are many times used in explanations, where we use a source analog to provide for the understanding of a target phenomenon. And this is very important to start with a general approach. So you have in analogy, you have a source that provides you with a certain piece of knowledge, and you have a target, which is something that you know something about, but there's another thing that you want to know about. So you always know something about the target. Otherwise, you're not analogizing. Um, for instance, um, you can use it as you know that ancient people knew that, for instance, metal was hot, and they wanted to know whether another sort of substance was able to be hot or not. And they know that that substance is comprised of a certain matter, but they do not know whether it has the property to heat. So, to striking an analogy means transferring the knowledge from the source, in which you know that there's a certain matter and there's the property of heating, to the target, which we know has a certain matter which might or might not be sufficiently similar to the former source. And you want to know, of course, according to valid and sound reasoning patterns, that whether it heats as well or not. So you can use it in many cases, and actually was the basis for human evolution. We evolved because we analogized whenever human creatures were faced with dangers. They would strike an analogy between wild animals or threats and other type of targets of which they knew not whether they would be dangerous or not. And the soundness of those analogies allowed us to survive and to be where we are today. So it is very important to know that both in general analogy and in legal analogy, there's a specific goal with analogizing. So you can analogize to fill in the gap of a legal system. If you have a gap in the legal system, you can analogize to make a political argument. You can analogize um, to explain a causal process, for instance, in a trial regarding whether a certain substance was the cause of a certain event or not. So there's many things that you can do with analogies with different ends, and it's very important to know that those ends are of paramount importance to analogy, because analogies change in accordance to whether those ends are or are not in place. And in legal analogy, what usually is the case is that we want to analogize or differentiate between classes of cases. So I would say that we have four scenarios, and I'll be using particulars P and Q. Usually those are the variables for logic. And the first scenario, we have a particular P is a member of category X, and the particular Q is a member of the same category X, but we conclude that they should, all things considered, be members of different categories. So we are disanalogizing. Scenario 2, particular P is a member of category X and particular Q is a member of category Y, when they should, all things considered, be members of the same category. So we are analogizing. Scenario 3, particular P is not a member of any category and particular Q is a member of category X, when they should, all things considered, be members of distinct categories X and Y. So again, we are disanalogizing or differentiating. And in scenario 4, particular P is not a member of any category and particular Q is a member of category X, when they should, all things considered, be members of the same category. So this is just to say that legal analogy need not be necessarily connected with legal gaps. We can use analogical reasoning or disanalogical reasoning to differentiate between legal cases that are put together within the same legal regime, when all things considered, they should have different outcomes. So I told you that I was going to outline a brief conceptual scheme, or I would clarify the conceptual apparatus of analogy. I only have the time to come up with 2 or 3 terms that I think are very important to analogy. So the first is a category or a class. So a class or a category, I'll be using them interchangeably, is a collection of sets that can be clearly defined by a property that all its members are share or are represented as sharing, whether you have the logical or psychological approach. So in the strictest sense, a category is the set of objects that are considered equivalent. Equivalent is a logical concept that can be sort of roughly translated into equal. So analogy basically focuses on whether, all things considered, 2 particulars ought to have the equivalent legal treatment. So the equivalence or the equality is different from the property of similarity, or the relation of similarity. Similarity is a relation between 2 or more particular objects when they are perceived as sharing one or more property. Do note that when we say that A and B are similar, we are not necessarily analogizing between them. So they may be similar, but not similar enough to deserve equal, equivalent, or analogous legal treatment. So this is what I wanted to highlight, the difference between similarity that exists in the real world that can be asserted between a comparison of particulars A and B, and analogy, which is basically instituted as some sort of equality that does not, as a normative concept, exist in the real world, but is set up or instituted or established by someone, which is the one who is comparing, and the one which has adopted as a criterion for the comparison a certain meta factor that will preside over the comparison. So equality has to do with and analogy has to do with some sort of tunnel vision that disregards the similar properties and focuses on those properties which are deemed relevant for the equivalent treatment. So how can we conceptualize analogy? Or the argument from analogy. The argument from analogy, as I said before, is the process of inferring that a property conclusion Q is to be predicated of a particular situation or object T, which is the target, from the fact that T shares a property or set of properties P with another situation / object S, which is a source, that has the property Q. So the set of common properties P is the similarity between the source and the target, and the conclusion property Q is projected from the source into the target. This is the concept that is probably more important in the analogical reasoning is the concept of relevance, the notion of relevance. So relevance is the predicate of a property of a particular. A certain particular has a certain property that is predicated as relevant when it is relevant according to a certain standard of relevance. The interesting thing, for instance, it's the fact that it's inflammable may be relevant for scientific analogies. The fact that it is conservative may be relevant for political analogies. In legal analogies, the concept of relevance is very, very tricky because it has to do with the concept of ratio legis, so the underlying reason or function of the law, which is highly disputed whether it really exists. Irrespective of that, the structure of the argument, of the analogical argument, is the conjunction of three logical steps that were mentioned in the initial class regarding what one can get from logic in the law. So the first step is an abduction of a relevant property. The second step is an induction, and the third step is the deduction. So when setting up an analogy in general and a legal analogy in particular, we are both purporting to have an inferential discovery and also a form of inferential justification. So how do we analogize? So we start by having a certain target of which we want to know whether a certain legal treatment is deemed valid, and it is not expressly foreseen in the legal system whether situation A leads to a permission of a certain action or to a certain action being forbidden. But we know that Q, which is has some sort of similarity, a level of similarity with A, is regulated as being forbidden. So basically what we come up with, and that's the tricky part of circumventing the ratio legis and having the best legal explanation, which would basically be arguing in accordance to legal principles, is the abduction. So we abduct that the best possible explanation, for instance, for vehicles not being allowed in the park is the protection of the environment. So that means that if an automobile is forbidden to enter the park, then a motorcycle, provided it pollutes as well, will also fall prey to the best explanation, and we get that theory as a justification for the source. Then we induct that all polluting devices are liable to go against the best explanation of the prohibition of automobiles entering the park. Therefore, motorcycles and I don't know, tractors and other type of combustion driven vehicles are also part of polluting vehicles. So those deserve as well the same treatment. And then basically we deduct, whereas the target is a specific particular kind of thing that is a part of the class that was inducted. So here we deduct that a moped, a motorcycle, is a type of polluting vehicle. So basically, you see, we have to finalize the conjunction of the abduction, the best possible explanation for automobiles being forbidden to enter into the park is the protection of the environment. That's an abduction. The best legal theory, it could be the protection of families or any other argument or justification, sorry. Then you have the induction, basically applying that best possible explanation to all kinds of polluting vehicles. And then you have the deduction. So this specific motorcycle is a polluting vehicle. So the legal treatment from the automobile is projected into the gap of regulation regarding the motorcycle. So this is the basic outline of the analogical argument. I hope you enjoyed it. Thank you very much.